Well, we could get going.
Yeah.
I'm just gonna do a little introduction. We're from Prince Lobel. We're first year SAPs with EO. Thrilled to be a part of it. Um, Trying to provide some content that would be helpful to members. One thing as lawyers we always say is everybody's got employment problems. The minute you have an employee. So I've asked today two of my colleagues, Steve Weatherhead and Amanda Thibodeau, to talk to us about some of those issues. Steve has had a long career at counseling companies and employment issues and entrepreneurs as well. He's been the general counsel of salary.com and chief employment counsel for Sapient Corp. He is a unique lawyer in that on his bio, he points that he was once employed by Bath Iron Works, but does not note that he graduated from Harvard Law School. It's an odd combination. And Amanda Thibodeau has had good experience in handling employment law issues from soup to nuts for a lot of her clients and ours. So I have nothing to add, but for wisecracks, so I will hand it over to Steve and Amanda.
Well, thank you all for joining. Is everyone seeing the presentation version, or are you seeing the notes on the side? Joe, what do you see?
See both.
Yeah,
I have the notes on the side and or
Amanda,
at least the key up of the I think you're all set.
Amanda,
Amanda.
if you hit the bottom right, that presentation button, that'll go.
The one looks like an easel.
Yeah.
Well, I'll as you're working on that, I will well, welcome everybody. I know I met a few of you anyway at the book signing for, I forget her name now, but I think Ms. Morgan, that was held at our office a few weeks ago. So I'm glad to see some familiar faces and glad to see we've got some attendance here. As Joe said, employment law is one of those issues that almost every business faces, or every business faces. If you don't have employees, you don't have a business. Not every employer, luckily, faces patent suits or securities issues or privacy issues, but everybody has employment issues. And it used to be fairly easy in the old days before remote work, and you had an office in somewhere in Massachusetts and 20 or 30 people sitting there, and you followed Massachusetts law. Things have gotten much more complicated for two reasons. One is the workplaces are now far more distributed than they have ever been, particularly post-COVID. And you can't just set up, wherever the employee is working, the laws of that state will generally apply to the employment relationship. And you may be walking into something you're not completely aware of. And secondly, states have gotten much more active, particularly the blue states, and not to be political, but it's a perfect alignment in terms of having more strict or more draconian requirements for employers. And even localities now, local governments are getting involved. For example, Cleveland has an ordinance on pay transparency. San Francisco has its own minimum wage ordinance, things like that. So you have to, unlike the old days where it was almost just federal law and a little bit of state law, there's now a lot of different laws that are in play and that often compete and conflict with each other. And to me, that's one of the biggest challenge for entrepreneurs who obviously, usually have cash flow issues and want to conserve that. They don't have a lot of time for distraction. They want to avoid that. And so what we're going to try to highlight today are some of the key issues that we have found in our experience, young businesses and even more mature businesses face, and some of the tips you can, and some tips to avoid, hopefully, some of those issues. The first one, we'll actually go to the agenda. I know most of you are, Amanda, are you able to go to the next slide? Or am I, oh, it looks like I'm driving. Actually, I'm not. Kaylee, if you can help Amanda with that, maybe. What we're going to talk about today is four key issues. I'm going to handle the first two, then we're going to hand it over to Amanda. We're going to talk about restrictive covenant agreements, whatever that means. We're going to talk about key wage and hour issues, which is where could be a lot of financial impact. There we go. Thank you. Independent contractors, leaves of absence, and then we'll have time for Q&A. We're happy to go over our allotted time if there's a lot of questions, and we can always be available afterwards for follow-up. So next slide. What is a restrictive covenant agreement? That's just a general description of what we call non-competes or non-solicits. A lot of people use these terms interchangeably, and it's actually very important to distinguish between them and understand the distinction. Because we all sort of say, they have a confidentiality agreement or they have a non-compete agreement. What they really have is an agreement that has some restrictive covenants in it. And the question is, which restrictive covenants do they have or should they have? This is the big five. Almost all my clients, regardless of size, have all employees sign some form of agreement containing some or all of these components. Confidentiality, that's an easy one, and that's usually provided to employees across the board. If you are an entity that develops intellectual property, either anything that's patentable, some sort of device or process, or copyright materials, things like that, you want to make sure that there's a contract whereby the employee assigns those invention rights to you. As, for example, as patent law works, and Joe, correct me if I'm wrong, the patent has to be filed in the name of the inventor, which is an individual, not a company. And without one of these agreements, in theory, the individual employee on your time has developed some valuable IP, and without the proper agreement in place, they own that IP, at least arguably. So that's something you want to avoid. And again, these are pretty common, particularly in Massachusetts, and most employees have seen these types of agreements. And then we're going to talk about customer non-solicits and non-competition, where things really get squirrely, shall we say, and a little more complicated. So next slide. So confidential information, you should define it in your agreement to be as broad as possible. Yet, tailor it to your business. If you don't say, formulas and chemicals and things like that, or drug, if you're a pharmaceutical company or something like that, but it should be financial information, strategic information, marketing information, anything that in the hands of a competitor or the public could cause you harm. And we have a lot of flexibility here under the law. So again, try to be as broad and explicit as possible to capture any type of confidential information you might have. Note, however, there are some constraints there. Under both federal law and state law, you cannot restrict employees from discussing their wages or compensation. So you cannot say in your confidentiality agreement, wage information and your salary is confidential. You can say it, but at the end of the day, it's not confidential and you can't enforce it. Under federal law, that's called the National Labor Relations Act. It applies to non-supervisors. You cannot, again, restrict non-supervisors from talking about their wages. And many state laws, including Massachusetts, have similar laws protecting employees from discussing those issues. So that's one key thing, broad as possible with that one caveat. There also should include a disclaimer for the Federal Defend Trade Secrets Act. Trade secrets are sort of confidential information on steroids, right? It's anything that's a trade secret is automatically confidential, but not necessarily vice versa. So trade secrets are really, the Coke formula. If you're, Amazon's algorithms or something like that, those are trade secrets. You never know when you're going to have one. So you want to protect yourself and build this into your templates and agreements with employees. Under the Federal Defend Trade Secrets Act, if you don't use specific language in the agreement, you as an employer cannot get the benefit of that statute down the road if there's an issue. And that the federal statute is favorable or more beneficial than state acts because it has it defines trade secrets more broadly than many state laws, and it has several more penalties available, and you get federal court jurisdiction. So the point is, it's language that comes right out of the statute. It's verbatim. It's just a cut and paste, essentially, but you want to get that in there. You should also extend the obligation of confidentiality to not only your own information, but any information you might have access to, or that the employee might have access to for their job, like customer information, patient information. If you're a federal government contractor, you'll get some information from the government. Essentially, anything the person touched while they worked for you should be included as confidential and not disclosable. I don't know if there's a question. We talked about IP for a second. Again, there's something called an assignment of inventions. If you look at it, it's pretty technical, but at the end of the day, really what it says is we own it, and you have to help us do whatever we need to do to perfect those ownership rights. For example, if the employee invented it and we want to file a patent, we have a contract that says the employee must sign it, and they have to help us actually issue that patent. So it's very important. It gets sort of, it doesn't come up a lot, so it tends to get forgotten. But it's very important to have those rights established right up front before the person starts to work. Okay, next slide, please. So that's confidentiality and IP. Those types of covenants should be given to every employee, regardless of role or duties. The harder question is, okay, should we bind our employees to other types of covenants that are more restrictive, like non-solicitation agreements, like non-competition agreements? There's several rules of thumb on this. Many clients say, I'm only going to give those to specific people, either by level or job function. I want all my scientists to sign them, or my sales folks, but I'm not going to worry about my finance or engineering team, for example. There's no right or wrong answer. It's sort of what fits your organization, and what the administrative lift will be, depending on your decision. But a few key points, and again, I know most folks are centered in Massachusetts, but there's two things I want to stress here, because again, I have found that younger companies have gotten tripped up by this. One is when you expand into another state, you don't necessarily think, oh, you register, you start paying taxes to the state, but you don't really think about, oh, maybe there's some other laws or things I need to do in this state that might change either my templates or my processes or my policies. And that's important to know up front. The second issue I want to stress is you're gonna see a lot of that in my presentation. State law versus federal law. Always remember there's potential state law lurking. In particular in Massachusetts, we've got even more issues. So customer non-solicit, what is that? That is an agreement by an employee that says, once I leave for a stated period, usually 12 months, I will not solicit those customers that I solicited on behalf of you, the employer. That's not a non-competition agreement. They can still go work for the competitor. They can go work for a direct competitor. But what they can't do while they're working there is solicit your customers. And obviously you want to be careful how you, and clear as to how you define customers. Note, however, those are illegal in California. So if you have folks that are there, or if you're expanding into California, know that those are simply just not enforceable. Same thing with employee non-solicits. What is that? That's an agreement by the employee. Again, regardless of whether they're working for a competitor, that says, I will not recruit all my former colleagues and start a new business, or completely raid the team on behalf of a new employer and leave you without resources, that sort of thing. Those are permitted in Massachusetts in particular. They're not permitted in California, and those are pretty valuable. You have someone who's sort of a Svengali-like person who leaves and joins this new company, and a lot of people liked working with that person, and they start calling, and before you know it, you could have a small or mass exodus. So those covenants are pretty common, and pretty well accepted, at least among the employee community. Where it gets tricky is with respect to non-competition agreements. One of the biggest myths in employment law, and I actually have another presentation where we spend 30 minutes going over the 10 biggest employment law myths. And one of them is, oh, non-competes aren't enforceable anyway. And the answer is, yes, they are. And people who say that haven't been burned by one yet. Because those who don't say that have either been an employer who's trying to enforce one against a prior employee, or they have one themselves that they're trying to negotiate or deal with when they're leaving their employment. So there are a couple of hard and fast rules. Again, California always comes up. Minnesota, North Dakota, and Oklahoma, you cannot have a non-compete agreement, full stop, period. Again, the non-compete agreement is different from non-solicit. Non-compete says you can't go work, you can't even walk in the door. You cannot sign an offer letter with this company, regardless of what your role may be. Versus, like we said, the non-solicitation, where you can work for a competitor, but some of your activities may be restricted. Many people think they're not legal in Massachusetts. We could do a whole presentation on how to structure a legally compliant restrictive covenant in Massachusetts, and maybe we can do that at some point. But just understand, yes, they are enforceable. They have to be structured properly. It may cost you a little bit of cash, depending on the situation. And they will be looked at pretty strictly by a court in the event of a dispute. But at the end of the day, they are enforceable, and we would recommend that you use them. Again, there's always a judgment call. You can use them across the board with all employees and then choose whether or not to enforce it when they leave. That's a preferred approach among some people where if employees move around, for example, if you hire an employee in California and their agreement says, as it should, the non-compete doesn't apply, and they later relocate to Massachusetts, unless you sign the agreement, assign a new agreement, or have your agreement reflect that, you might lose that coverage. So you want to make sure it's structured in a way that's going to capture future changes, as well as be as enforceable as possible in the jurisdictions where you are. It's very easy to just give them across the board. I think it's a favorite approach if you do it correctly, and then just make the decision on the back end not to waive. The last thing you want is some key person who, for whatever reason, doesn't have a non-compete and they're leaving to join a competitor. So you don't want to be caught in that situation. I covered a lot there pretty quickly. Most of this can be addressed in one single document. This is not like you have 5 or 6 different documents. These can be handled with the drafting pretty easily. You can build it into your HR onboarding system or part of your hiring process. One of the big keys in Massachusetts, not only is the substance of the agreement, but the process. You must give it to people 10 business days. So we'll call it 2 weeks before they start. You can't have someone sign it on the first day. So that's called a springing non-compete, and they used to be allowable where there's been no discussion of a non-compete. I show up on day 1, I'm getting my phone, I'm getting my desk, and they said, oh, by the way, here's a non-compete. And you're like, whoa, I just left my other job. I didn't know I had to sign a non-compete. So the new law prevents that. I just got a question about when I say structured properly. The Mass statute is sort of a one of a kind in the US in the way it works. Structured means it can't be more than 12 months of a non-compete. It still has to be narrowly tailored to your business. It actually has to say in the agreement itself, advise the employee that they have a right to seek counsel. There was one federal court case where that simple sentence was omitted from an otherwise perfect agreement, and the judge threw it out because it didn't technically comply with the statute. Has to be signed by the employer. I see a lot of older agreements where there's an employer block, but no one actually ever signed it. The employee did. In pre-statute, that would have been okay, but now the statute says it's got to be signed by both parties. Doesn't have to be a wet signature. You can sort of have a template made with an electronic signature already built into it. That's fine, but it just can't be an empty block. And there's a couple of other sort of procedural requirements that fail to come to mind at the moment, but that's what I mean by structured properly. If you follow the statute, make sure you do all the procedural and substantive things. At the end of the day, you could have an enforceable agreement. We don't expect any changes to the non-compete law, at least to the legislation itself. What we do see is in just last week, a new court opinion came out. The law is still fairly new, 2018. A new court opinion came out that clarified one of the issues that people have had with the statute in terms of we weren't really sure how it was going to work. And now a judge has provided some clarity. Unfortunately, generally favors the employee in that case. But aside from sort of judicial clarity or guidance, we don't expect any activity in the non-compete world. A couple of years ago, in Massachusetts anyway, some states are still trying to toy with restricting them completely. New Hampshire had a referendum last year. It was voted down. A couple of other states. And at the federal level, a few years ago, sorry, I saw a comment and lost my train of thought. You can only get 1 year in Massachusetts, by the way. I think that's one of the questions floating around. Under the statute, it can't be more than 12 months, period, full stop. So if it's 13 months, you're only going to get 12. A few years ago, the federal government, you may recall, under the Biden administration, was focusing on non-competes. The Federal Trade Commission declared them illegal. All that activity has died down. The new FTC is focusing only on healthcare entities. So if you're one of those, you might still have some federal non-compete issues. But generally, this is a game that's played at the state level. And after some activity the last few years, that's sort of settled out for the moment. So I'll stop there. I know it took a little bit more time on that. Stop there and move on to the next key point. I'm happy to take questions later on this. Key wage and hour issues. This is where a small mistake, even if it's very technical, can cost you literally a lot of money, tens of thousands of dollars. And no one likes paying out money more that they don't have to pay out, or that could have been avoided with something very easy. 5 key issues in the wage and hour world: minimum wage and overtime. Those are fairly easy. They've been around long enough that we have a good handle on those. And then there's vacation, commission plans, and payment of final wages, all of which in Massachusetts in particular are very complex. And again, one small and rife with traps for the unwary, we'll say. So next slide. Minimum wage and overtime all derives from the Federal Fair Labor Standards Act, which has been around since the 30s. We all have a good handle on that. What some smaller companies forget, though, is that in addition to the federal requirements, state laws also have their own overtime or minimum wage requirements. Massachusetts, I think, is up to $17 an hour. Don't quote me on that. And the reason don't quote me on that is that a lot of the statutes now are indexed, so they go up automatically every year. So on January 1, you need to make sure you're paying the appropriate minimum wage in the jurisdiction in which your employees are working. And again, that can vary from state to state and from year to year. And I'm going to say one thing as an aside, too, which applies to wage and hour laws and basically all the laws we're talking about today. And again, this is not political. But if you want to just sort of have a shorthand of, are the laws going to be basically the federal law, which is a fairly, low base or low baseline, or is that state going to have more substantive and complex and different requirements? And if it's a blue state and it's almost a perfect overlap, there's probably going to be some extra requirements. If it's a red state, there probably won't be. And again, perfect overlap. There are 3 states where, from an employment law perspective, it's kind of purple, and they just happen to be the battleground states: Pennsylvania, Wisconsin, and Michigan. So that's always just a good shorthand in terms of thinking how you want to approach this. We could spend, again, a whole session on overtime. There are thousands and thousands of regulations. Just remember, again, there are state law issues, and that the key is determining whether someone is exempt from overtime or non-exempt. And again, one of the biggest myths, number 2 of employment law, is if I pay them a salary, they're not subject to overtime. And that's wrong. That's only part of the analysis. Yes, you do have to pay them a salary, but on top of that, they have to satisfy what's called the duties test. You may be familiar with this, either the executive duties, administrative duties, computer professional, etc. But the point is, simply paying on a salary basis is not sufficient. Where are the big traps that we see when it comes to overtime? One is that issue of assuming just because they're paid salary. One is misreading the regulations. In order to be exempt under the administrative exemption, which is a misnomer, you have to have a job that requires independent discretion and judgment, among other things. Well, if you don't really know what that means, that's any job, right? If you just look at those words literally, everybody's going to satisfy the test. So there's a lot of stuff going on behind those words, and a lot of years and years of case law as to what that really means. So you want to be careful relying on just a few little words in a statute or the words administrative or professional, which are used in a different, or terms of art under the FLSA and not necessarily used as we do commonly. Where do I find the most misclassification? Hands down, inside salespeople. What is an inside salesperson? Remember, this statute was drafted years and years ago when we didn't have the internet and things like that. And if you were a outside salesperson, is a traveling salesman, you know, the person that would sell encyclopedias at your door, show up at your company to sell paper, sell vacuum cleaners, etc. Those are outside sales. If you sell, or if you're a salesperson and you sell strictly by telephone or the internet or online, and you never visit the customer, that is an inside sales job, and that is non-exempt. Full stop. The law is very clear on that. And that's where a lot of folks come in. Oh, they're in sales. Of course, they're exempt. And you know, it goes along swimmingly for a while until there's some disputes or there's a termination, and then all of a sudden someone sees a lawyer and realize you've been misclassifying someone for several years. And the damages in Massachusetts in particular for these types of cases can be very high. So you want to periodically do an audit, particularly if you're growing, of your classifications. Make sure they're up to snuff. Get a review if you think it might be necessary. Okay, next slide, please. This one seems simple, right? You can put it in the chat box if you want, and I can call them out. But if, as a small business owner, you deal with a lot of contracts, right, and agreements at all levels of the business. If I had to ask you what your most important contract is, I'd be curious for your business. I'd be curious what your response would be. Is it your master services agreement with your most important client? Is it your statements of work? Is it your lease? And I would assume that a lot of those documents you probably put a lot of thought into, a lot of care into them. Maybe you even get legal counsel to assist you on those. I'm here to tell you that vacation policies and commission plans, while they seem much less important or significant, if not done correctly, can cause you more risk and trouble than some of those other documents I just mentioned. Particularly when it comes to commission plans, where there's literally a paper napkin that says, here's your commission, and you haven't thought of all the variables or the potential, what if this, what if that, and you really need to think that through. So when it comes to vacation, first, unless you're in Nevada or Maine, there is no legal requirement to provide people with vacation. That's another myth. No requirement. Put aside earned sick leave, that's a different issue, but there's no requirement to provide paid vacation. Of course, most employers do, as a matter of recruitment, if nothing else. And you essentially have two options. The good old-fashioned, and which I like, accrual policy, which is you get 3 weeks of vacation a year, and you're going to accrue X number of hours every pay period, and then you discuss whether there's a roll, use it or lose it, or you roll over any accrued amounts, what have you. But at any given point in time, you know exactly how much vacation that person has and how much they've used, because the big trick is you have to pay that out upon termination potentially. If you have an accrual policy, you want to be very clear as to not only how many days are accrued, but when. I had an issue recently where the policy said you get 3 weeks of vacation a year, and the person left in end of January, and the employee said, well, I get paid out 3 weeks of vacation, and the employer said, well, no, we accrue it over time, but it didn't say that in the document. And so the court took the position, and I can't argue with him on this one, is that it says 3 weeks. They got 3 weeks on day one. If they left on day two, you owe them the 3 weeks. So accrual can help you, manage those cash impacts when people leave. It should also be very clear about how much can be rolled over, whether it is use it or lose it, which is not permissible in certain states like, I guess, California, but certainly okay in Massachusetts if structured right. So that's one type of policy. The second one, which appears to be all the rage, and I say appears, has several names. Unlimited, which is a horrible word. Flexible, non-accrued, which is the sort of, look, take the time off you need. You're professionals, get your job done. Don't be stupid about it. But we're not going to put any particular restrictions. First, those are not as common as people think. They're really hot in some of the techie areas and certain places in California. So they tend to get a lot of attention. But generally, they're still in the minority of policies around the country. And they do have some problems in the sense that even in Massachusetts, if you have a flex policy that says take as much time as you want, and that document says, but you've got some field manager or somebody in the company saying, yeah, but you better not take more than 3. The case law says you just turn your flex policy into a 3-week policy. Okay. So not only is it important to have the document correct, but you got to have your process locked down as well. I encourage employees to use accrual policies. Employers, I have been losing that battle more and more. But those are sort of the pros and cons of each of those. So we'll go to the next slide. Commission incentives plans cause even more problem. Commissions are considered to be wages under Mass law. Therefore, you can't unlawfully restrict them or withhold them, and you must pay them out if they're earned when somebody leaves the company. Again, like your vacation plan, your commission plan should be very clear as to what is commissionable, when, what products, what services. Is it based on EBITDA? Is it based on sales revenue? You define any term that's not known. You know, we define sales revenue as X less cost of sale, whatever it might be. You want to have all of that clearly laid out. And the most important part of the agreement is, when is the commission earned? And that can be at several stages. It could be earned when the PO signed or the contract signed. It could be earned when you invoice the client. It could be earned when the client ultimately pays you. But you want to have at least that set out in your document very clearly, so that when somebody does leave, which will happen, it's very clear what the rules are and what you need to pay them out when they leave. And so again, commission plans, and I have some clients who have very technical businesses. Their commission plans are 20 pages. They're very complicated. There's a lot of math in it, but there's always some key terms we want to make sure. There's no legal requirement to get those out on January 1. I have a lot of clients who get them out in February or March, retroactive to January 1. That creates some practical legal issues, right? How do you incentivize someone if they don't know what they're being incentivized to? But you should strive to get those out, as early in the sales year as possible. And the final issue on wage and hour is the payment of final wages. Again, clarified by some Supreme Judicial Court case law over the last couple of years. And remember, there are state differences, but we're going to focus on Massachusetts, because if you follow Massachusetts law, you will always be complying with any other state possible, because we have the strictest law here. The issue is, if somebody is being involuntarily terminated versus resigning, they must be paid on the last day of employment. Not the next day, not the next payroll cycle, not next month, on that day. I'm terminating someone on Friday. I walk in, I give them whatever, and they either get a paper check or they have a direct deposit that has to hit their account that day. There is a case where someone was terminated on a Friday. The direct deposit hit on Saturday. And the employer said, okay, yes, technically they didn't get it, but had I given them a paper check yesterday, the check would not have cleared yet. They actually got access to their money quicker. And the judge said, no, they were not paid on the last day. So don't assume your payroll processor knows that. You want to make sure or your payroll person, you want to make sure you're very clear. Sometimes you don't have the luxury. Usually you have the luxury of planning an involuntary termination, so you can sequence it in a way or make sure you get the checks lined up. Sometimes you don't have that luxury. Someone's done something really bad, a really egregious situation. You need to march them out the door that day. The best remedy for that, although it costs you a couple of bucks, is to, yes, send them out that day and relieve them of duties, but have their termination date be 2 days later, right? And then pay them out those 2 days later, the final week. Cost you 2 more days of wages, but you're not running into a wage and hour issue. So that's some of the nuances that you have. What happens if you violate that law? Oh, and by the way, accrued vacation and PTO in Massachusetts has to be included. So it's your final paycheck, your salary, plus any accrued vacation or PTO. And if you have one of these flexible policies, that's where we get into issue. Like, what does that really mean? If you don't do that on time, you get automatically charged with 2x the amount plus attorney's fees. And sometimes final wages, if it's a highly comp person or if they have a big of a vacation accrual, the final check, particularly if you pay monthly or even semi-monthly, could be $10,000, $12,000, $15,000, and all of a sudden you're doubling that. And there is no defense to it. It doesn't matter if it was an administrative error, if there was a power outage, the government shut down, it doesn't matter. It is called a strict liability statute. That's something that I really, we really stress with our clients, even big companies who have a lot, are using ADP or paychecks will get this screwed up. They're running very fast, and sometimes these things fall through the cracks and they have to write some big checks. So with that, I'll end the key wage and hour issues. One thing you could do, so we've talked about minimum wage, overtime, commission plans. Hey, let's make it easy. Let's just hire them as independent contractors, right? Solves all the problems. Well, as Amanda's going to say, not so fast. That's not necessarily the panacea that many think it is, and it can help you with wage and hour issues, but can actually create even more. So with that, I'll turn it over to Amanda. Thank you, everyone.
Thanks, Steve. So nice segue into another misclassification issue that we see as a really big trap for the unwary, especially for startups and small businesses who maybe don't, have a lot of liquid cash or cash strapped. So you're thinking, okay, I don't have the money to pay this person minimum wage or the salary threshold. Let me characterize them as an independent contractor. I'll pay them some equity, and no problem, right? Maybe a problem. Massachusetts, like our other blue states, as Steve mentioned, it has one of the stricter state tests when it comes to whether or not you can have somebody classified as an independent contractor. And in Massachusetts, we're going to assume that the person that you're hiring is an employee, not a contractor, unless they meet this very strict test, which we call the ABC test. You may have seen this come up, in recent years. California has this very same test. That's where Uber and Lyft were getting into a lot of trouble. So we've been seeing the ABC test sort of enter the lexicon of the general public. And the ABC test has 3 parts. Control. You need to prove that the worker is free from your direction and control. Meaning if you're controlling schedules, you're controlling what meetings they have to go to, you're controlling what hours they're working, what tasks they're performing. And of course, every single contractor, even a true contractor, is going to be subject to some control. However, it's a balancing test. And so you're going to look at this person and say, okay, how, am I relying on this person and their expertise to say, this is what I want to do, and then the person can go and run with it, right? So a common example I always give to our employees or to our employers is you hire an accountant, right? Your small business needs an accountant in order to balance the books. You are not necessarily micromanaging the accountant, right? You say, I need you to balance the books. The accountant goes and says, okay, goes into QuickBooks and does their thing, right? They have a minimal amount of control over how the accountant is performing the work. The second is what type of business and what type of duties is this person performing? Is it outside the usual course of your business? So a common example for this is a salesperson, right? The salesperson is really integral to the business, and you're not going to have a business without the salesperson. So even though your business may be, something having to do with tech, the fact that your salesperson is selling that process to your clients is integral to the business. They're not performing something outside the regular course of business like your accountant in the previous example. The person balancing your books is not in the business of selling your algorithm, right? The third is the person's customarily engaged or can be engaged in performing similar work for others as part of an independent business. And this, again, we go back to the accountant example. Maybe they have the ability to perform accounting services for other small businesses. This doesn't mean that they absolutely do. It just means that they have to have the ability to do so. So if you have somebody that you're bringing on as an independent contractor, but you're making them work 40 hours a week for you, they're likely not going to have the ability to provide that service for others because they already have a full-time gig with you. So all 3 of these prongs must be met, or we're going to assume that they're an employee. Oh, I see a question come in. Sorry. So
Yeah, I think
if
you're
it's
talking to me.
international, yeah, it becomes very complicated. Every other country or most other countries also have rules surrounding independent contractors. I see this quite often, especially with smaller businesses, that they'll say, well, I need a software developer. I'm going to hire somebody out of India and I don't have to worry because they're out of the country. Big problem, especially India has gotten on this issue. And so they have very strict laws internally as well about how you can classify somebody as a contractor. So consult your friendly employment lawyer on these types of issues. It's not going to be a end all be all conversation that they have to be an independent contractor or they cannot be. Oftentimes, if they meet that test or they don't meet the test, we may have to hire them through a PEO internationally. So unfortunately, it's not a simple answer. So why do we care about how we're classifying it? What's the big deal? Like the wage and hour issues, it can cover significant penalties and liability. I've seen these types of issues, run into the hundreds of thousands of dollars. If individuals have a private right of action to bring these types of cases to the employer, into a court, and they can get potentially back wages, overtime that they otherwise should have been entitled to, vacation pay and value of other benefits like health insurance, unemployment and workers' compensation contributions that should have been made on their behalf, tax withholdings that should have been made on their behalf, and also civil penalties from the Attorney General's office can be levied as well. And like our wage and hour issues, if you get nailed for this, you get triple damages plus attorney's fees. So you have $100,000 liability based on these penalties. Now it's 300. So this can be a real killer for small businesses. It's a mistake that you don't want to make. And so how do we minimize this risk? We want to make a very careful analysis of the relationship.
Amanda, I'm sorry to interrupt you, but if I could just say one thing. This is not something you generally can get insurance for either, because it's a wage. Your insurance company will pay for your defense costs, but if the damages are considered to be wages, you're still going to have to pay that out because the insurance company's not going to subsidize your payroll. Sorry, Amanda.
Yeah, no worries. That's a good point. So how do we minimize this risk? We want to do a careful analysis of the relationship before we engage with this individual, making sure that they're meeting the ABC test. It's very fact dependent. There's a number of things that you can look at, and it is one of those things that is not black and white at all. So, what may be okay in one scenario may not be okay in another, depending on what other factors we're looking at. So always be sure to do an individualized assessment of each person before you engage with them. If we get through there and we decide, yes, we think that this person meets the ABC test, you want a written contract with each of those contractors. It may be individualized again to each contractor, depending on the relationship and what services you're expecting them to perform. Just because you have a written contractor with a contractor, however, does not mean that that document is going to control for purposes of beating the ABC test. So I just want to make that very clear. Us lawyers, we like to put in all sorts of protective language in those contracts. This person understands they're a contractor. We have no control over their performance. All that great protective language. The court could look at it and say, that's nice. We don't see it that way. Throw out the contract. They're actually an employee. So do not feel insulated by good, tight contractual language. You still have to go through that analysis to make sure that we're meeting that ABC test. And then, of course, we want to revisit our classifications early and often. Sometimes the business model is going to change. That's okay. We want to make sure that we're looking at these things on a very, frequent periodic basis to make sure that this person still should qualify as a contractor. What oftentimes I'll see as another risk factor is somebody, is hired as a contractor and then they say, yeah, we really like this person. We're going to bring them on permanently and then have them flip to an employee. That's probably okay if we can justify that. But if you have the same person who's performing as a contractor and then as an employee or vice versa, that tends to raise the risk level. So we need to make sure that we're justifying those reclassifications carefully. All right, so we're going to jump to leaves of absence. As Steve mentioned, any one of these topics, we could probably spend 8 hours on, so we will not. I'm doing a very, very broad overview of each of these. The leaves of absences that I've listed here, the Paid Family Medical Leave Act is a Massachusetts-specific leave, Massachusetts parental leave, Massachusetts earned sick time law, which we'll discuss in some detail. I'm not going to talk about the Federal Family and Medical Leave Act, which we refer to as the FMLA generally. That's a federal statute, and that only becomes relevant for you if once you hit 50 employees. So it's certainly good to have, you know, the knowledge of it, and then it may be coming down the road, hopefully as you're getting bigger. But for now, we're not going to worry about it. And then we have other types of leaves that can be specific to Massachusetts and other states. We have another military leave law. We have a domestic violence leave law that also applies only to employers over 50 employees, but good to know. We have a jury duty leave law, voting leave, and a small necessities leave, which also applies to 50 or more employees. But these are all specific to Massachusetts. If you have employees in other states, a lot of states have variations of these types of leave laws as well. So as Steve mentioned, make sure you know what you're getting into when you're hiring folks from other states. There may be other requirements, other leave laws that you need to worry about. Say one of the biggest concerns that you need to worry about from day one is the Massachusetts Paid Family and Medical Leave Act, the PFMLA. It covers employers of every size, no matter if you have 1 employee or 50 employees, you're in. And what this does is it's a leave law that covers medical and bonding leave. So medical leave for yourself or to care for a family member, bonding leave for a new child, and it does have a military related leave as well. So it's a state-run program. It operates a lot like the unemployment system, in which the employer and the employee are paying into a fund. And the department that runs that is this Massachusetts Department of Family and Medical Leave. So they're the ones that are administrating the program. They're collecting all of those contributions. They're making determinations about eligibility, and they're paying your employees when they are availing themselves of that leave. Employers have to post notices related to the Paid Family Medical Leave Act, and you have to include it in onboarding. So every time you're hiring an employee, you have to provide a notice to them regarding their rights under the law. So length of leave, we have 12 weeks generally for family leave. That's that bonding leave. So if you have a new child, that covers foster children and adoption as well. 20 weeks of leave for your own serious health condition. 20 weeks for a covered service member for that military leave. And this is annually. So it resets annually. So if you have an individual who takes bonding leave to have a child, following year they have a second child, as long as that has reset, they may use another 12 weeks for that bonding leave. So I mentioned the DFML handles the eligibility and determinations for this, so you don't have to worry about it so much. We like to make sure that we have internal policies so that you can administer it to some extent on your end, but generally the DFML is going to be the one that decides eligibility. There is a private plan exemption available. Most smaller businesses try not to deal with that. It's just easier to have the DFML handle everything otherwise. But certainly if you have a broker that you use short-term disability and things like that for, that's a service that a lot of them also provide. So you can certainly look into that if that's something you're interested in. There are rules surrounding, the employee providing notice. There is some flexibility, obviously, for issues that arise beyond the employee's control. So, for example, if somebody's going out on leave for recovery for a heart attack, they generally don't know 30 days in advance that they're going to have a heart attack, right? So there are some exceptions. There is an anti-retaliation provision as well. So we're not allowed to punish employees or take any adverse actions against them based on them exercising their rights by taking leave. So we want to make sure that we're not demoting, we're not firing, things of that nature. The Massachusetts Parental Leave Act. So this one is similar. It was a precursor to our Paid Family Medical Leave Act. So it deals strictly with the parental leave portion of the law. Certain employers must provide eligible employees with up to 8 weeks of unpaid job protected leave for the birth of a child or adoption. This is covered for employees of 6 employees or more. So as the PFML, you have 1 employee, you're in. This only applies if you have at least 6 employees, and it is unpaid. So generally, if you're utilizing the PFMLA, you're generally okay under the Mass Parental Leave Act as well. There is some other eligibility here. You see that the employee has to have worked full-time for at least 3 consecutive months, and leave must be taken at the time of the birth or adoption. So it's slightly different than the PFML in terms of those eligibility requirements. There is a notice requirement for this as well, one of those work time posters that you have to put in. For folks who are working mostly, online or hybrid, we often suggest, I get this question a lot, well, how are we supposed to post a notice? We don't have a break room, right? Putting that inside of your intranet service is generally enough. And then our Massachusetts Earned Sick Time Law, this is another one that you'll encounter right away. So this applies to all employers regardless of size. And employees get 1 hour earned per 30 hours worked, up to 40 hours per year. So we have this accrual process, this accrual formula. If you have 11 or more employees, that time that is accrued is paid. If you have fewer than 11 employees, it's unpaid. You have to provide that time off, but you don't have to pay them when they take that time off. And there are specific uses for this. It can be for the employee's illness or family illness, medical appointments. There are domestic violence related reasons as well. And as of last November, to care for themselves or their spouse in the event of a pregnancy loss or failed assisted reproduction, adoption, or surrogacy. So this type of leave, even though we're accruing hours, and especially say they're eligible for paid earned sick time, this does not have to be paid out at the end of employment, unlike the vacation time. So you can keep track of it, but at the end of employment, it goes away. And you can set rules around the rollover. You have to be able under the law to roll over up to those 40 per year, but you're allowed to otherwise cap it. So that was a very, very short run through of our leave laws. We do have a few minutes left for questions on all of this, so feel free to fire them off.